Good morning, sir. I am Cindy Merodinas from B Scream 4F. This is my discussion on this subject, CLJ 6 Criminal Procedure from Rule 110 to 126. First is Rule 110, Prosecution of Offenses. Rule 110 of the Philippine Rules of Court explain how criminal cases are started and what information is required in order to file a complaint or information in court. Section 1 outlines how criminal actions are initiated. If the offense requires a preliminary investigation, as specified in Rule 112, the complainant files the complaint with the appropriate officer for investigation. For other offenses, the complaint or affirmation can be filed directly in the municipal trial courts or with the office of the prosecutor. Section 2 describes that a complaint or information must be in writing in the name of the people of the Philippines and list of all persons responsible for the crime. Section 3 defines a complaint as a sworn written statement that charges someone with a crime signed by the offended party, peace officer, or a public officer enforcing the violated law. Section 4 defines an information as a written accusation by the prosecutor charging a person with a crime and filed in court. Section 5 discusses who is responsible for prosecuting criminal cases. Generally, prosecutor directs the prosecution, but in some cases, such as in municipal trial court, the offended party or peace officer may handle in municipal trial court, the offended party may handle the peace officer may handle the prosecution if the prosecutor is unavailable. Section 6 explains that a complaint or information is sufficient if it includes the name of the accused, the designation of the offense, a description of the acts or omission that make up the offense, the name of the offended party, and the approximate date and place the offense was committed. Section 7 says that complaint or information must state the accused's name, if unknown, use a fictitious name. Section 8 states that the offense must be identified by the statute under which it is defined. And Section 9 requires the complaint or information to describe the act or omissions that constitute the offense clearly and concisely so that a person can understand the charge. Section 10 explains that the complaint or information should indicate the place where the offense was committed, unless the location is a critical element of the crime. And Section 11 clarifies that the exact date of the offense doesn't need to be stated unless it is a key element of the crime. And in Section 12 says that the complaint and information must name the person who was offended or describe them if their name is unknown. And Section 13 prohibits charging more than one offense in single complaint except when the law prescribes a single punishment for multiple offenses. Section 14 discusses the amendments of or the substitution of the complaint or information. Before the accused pleads, the amendment can be made without court approval. After the plea, amendment need court approval. Amendments cannot downgrade the offense or exclude accused person without prosecutor motion and court leave. And in Section 15 explains where the criminal action is to be filed. Generally, it should be filed in the court where the offense was committed, or in the case of crime in vehicles or vessel, it may be filed in any jurisdiction the vehicle or the vessel passed through. Section 16 allows the offended party to intervene in the criminal action if they are seeking civil damages in the same case. Next is Rule 111, Prosecution of Civil Action. Rule 111 explains how civil action related to criminal cases are handled. When a criminal case is filed, any claim for civil liability, like damages caused by the crime, is automatically included unless the victim explicitly waives it, files it separately, or reserve the right to do so. This means the court will address both the criminal and civil action together, saving time and effort. However, if the victim files the civil action separately, the proceeding on that claim are paused until the criminal case is resolved to avoid conflicting decisions. In some cases, civil actions can proceed independently, especially if they involve issues like negligence, fraud, or violation of personal rights. This to be depend on the outcome of the criminal case, but the victim cannot recover damages twice for the same act. If the accused dies during the case, the civil actions tied to the crime is extinguished. However, independent civil actions or claim based on other obligations can still continue against the accused, state, or legal representative. Finally, this rule ensures that civil liability arising from criminal acts is resolved either alongside or separately from the criminal case, depending on the victim's choice. Next is Rule 112, Preliminary Investigation. Rule 112 focuses on the processing, focuses focuses on the process of determining if there is enough evidence to bring a case to court. A preliminary investigation is required for serious crime when the penalty is at least is at least 6 years and 1 day. It ensures that the investigation it ensures that the only only case with probable cause proceed to trial. The investigation is conducted by prosecutor or authorized officer. The complainant submits affidavits and evidence, while the respondent can reply with counter affidavits. If probable cause exists, the prosecutor files the case in court. If not, complaint is dismissed. This rule ensures the fairness and prevents baseless case from clogging the courts. Next is Rule 113, Arrest. Rule 113 defines arrest as taking a person into custody to face charges. Arrest can be made with or without warrant. With a warrant, a judge issues to the warrant. An arresting officer must inform the accused of the charges and show the warrant unless doing is unsafe. Without a warrant, allowed when a crime is committed in the officer's presence, immediately after the crime is committed, or when his escaped prisoner is apprehended. Arrest must be conducted without unnecessary force, and the person must be brought to the nearest police station promptly. Next is Rule 114, Bail. Rule 114 governs bail, which allows an accused person to remain free while awaiting trial by providing a guarantee to appear in court. Bail can be in the form of cash, property, or surety bonds. The amount is determined based on factors like the accused's financial capacity, the severity of the crime, and the risk of flight. Some crimes, such as capital offenses with strong evidence of guilt, are not bailable. The rule also covers the cancellation or forfeiture of bail if the accused violates its condition. Next is Rule 115, Rights of the Accused. It outlines the fundamental rights of the accused in criminal case. These include the right to be presumed innocent until proven guilty, to be informed of the charges, to have a lawyer, and to be present at trial. The accused can cross-examine witnesses, present evidence, and refuse to testify against themselves. They are also entitled to a speedy, fair, and public trial and can appeal decision if allowed by law. These rights can ensure the accused is treated fairly throughout the legal process. Next is Rule 116, Arraignment and Plea. Rule 116 deals with arraignment, where the accused is formally informed of the charges and asked to plead guilty or not guilty. The arraignment must be in language the accused understands. If the accused pleads guilty, the court ensures the pleads voluntarily and understands its consequences, especially for serious offenses. If the accused refuses to plead guilty, the court enters a not guilty plea on their behalf. The rule also allows plea bargaining, where the accused can plead guilty to a lesser offense with the offended party and prosecutor consent. Next is Rule 117, Motion to Quash. Rule 117 allows the accused to challenge the complaint information before pleading. A motion to quash can be filed on grounds like lack of jurisdiction, insufficient allegation, or double jeopardy. If the motion is granted, the case is dismissed, but a new case must be filed unless barred by law. This rule ensures that only valid cases provided to proceed to trial, protecting the accused from unnecessary legal proceeding. Next is Rule 118, Pre-Trial. Rule 118 makes pre-trial mandatory to simplify and expedite trials. During pre-trial, the court and parties discuss matters like plea bargaining, evidence marking, stipulation of facts, and objection to evidence. Agreement made during pretrial must be written and signed to be binding. The pretrial process reduces the scope of disputes, making the trial more efficient and focused. Next is Rule 119, Trial. Rule 119 governs the trial process where the prosecution and defense present their cases. After arraignment, the accused is given at least 15 days to prepare for trial, which should start within 30 days of the pre-trial order. Trial are continuous to avoid delays, and evidence is presented in an orderly manner. The prosecution presents its case first, followed by the defense. This rule ensures the accused right to speedy trial and prevents unnecessary delay in resolving case. Next is Rule 121, Filing of Criminal Complaints. Rule 121 of the Philippine Rules of Court focuses on the procedures for filing criminal complaints. It starts with the process of preliminary investigation, where the prosecutor reviews the evidence submitted by the complainant or the person claiming to have been wronged to determine if there is enough basis to charge someone with a crime. If the prosecutor finds sufficient evidence and information is filed in court and the case moves forward. If the evidence is inadequate, the case can be dismissed. This rule ensures that criminal cases are filed in court only when there is enough proof to support the charges, preventing unnecessary trials or wrongful accusations. The purpose is to protect individuals from facing criminal charges without sufficient evidence. Lastly is Rule 126, the issuance of search warrants. Rule 126 pertains to the issuance of search warrants, which are legal documents that give law enforcement officials the authority to search someone's property, just as their home or their vehicle, for evidence of a crime. According to this rule, law enforcement officer must present enough information to a judge proving that there is a probable cause to believe that evidence related to a crime will be found in the place they wish to search. If the judge agrees, they issue a search warrant, allowing the search to proceed. This rule ensures that searches are conducted legally and protects individuals from unreasonable or unjustified intrusions, balancing the need for law enforcement to gather evidence while respecting personal property. And that would be all, sir. And thank you so much for listening.